All right. Good morning to both of you, and welcome to the 5th District Court of Appeal. With me this morning, I have Judge Wallace and Judge Pratt, and I am Judge Kilbane. This morning, we have for oral argument, Lewis versus Lewis. It's case number 23-1244. And Mr. Simarcos, I will assume 5 minutes for rebuttal unless you tell me otherwise.
Yes, Your Honor. 5 minutes for rebuttal. Thank you.
All right, thank you very much. And with that, you may go ahead.
May it please the court, counsel. Good morning, Your Honors. My name is Charles Simarcos, and I represent Sangeeta Lewis, who is the appellant and the former wife. This is an appeal on the order of the former husband's motion for temporary fees. And Your Honors, really cutting to the chase, the essence of the appeal is that the trial court did not have continuing jurisdiction over the claims that are being raised by the former husband in the amended motion. I know procedurally the statement of facts outline this, but this comes out of a divorce. The parties were ordered to sell a company. The wife during the divorce after the dissolution was to receive all the profits and the proceeds. They had a period of time. 2 years after the divorce, she finds another piece of property, opens a new corporation. And just for purposes of the argument, Your Honor, if it's permissible, I'll be referring to the entity that existed at the time of the divorce as the old company and the entity that was formed after the divorce as the new company. The names are somewhat similar and they're in the brief. But the initial argument, Your Honors, is that the trial court did not have jurisdiction or continuing jurisdiction because this is not an action to enforce the agreement. What this really is an action seeking damages for a variety of alleged claims, in that it's alleged that my client, the former wife, supposedly 2 years later formed this entity for somehow a purpose to defraud the former husband, when in reality, the new entity was formed, real estate was purchased that did not exist at the time of the dissolution action or the marital settlement agreement. The business has operated simultaneously during a period of almost 2 years until the old company, the lease could not be renewed and it shut down. Now, factually, Your Honors, we've argued that the record itself lacks a number of the claims a number of the allegations that might even support some claim for what the court has. But to start off, Your Honors, the first argument where there's no jurisdiction in citing the Palucci Florida Supreme Court case is essentially that a party cannot seek general damages in order to get breach of contract damages under a Chapter 61 or under continuing jurisdiction of a family law court. The remedy is to file separate action. The Kozel case, which we cited, Your Honors, which is basically another continuing jurisdiction case, that is a second district case where essentially the former husband was supposed to transfer shares of stock, give tax information. It was alleged that he didn't do it timely, didn't do it properly, and then when he did it, he caused the wife damages because of the tax information. And the court went through, the second district court of appeal went through a great deal of analysis, but what they ultimately held was that this was not an action to enforce an agreement, but what was done in the Kozel case was to try and get damages, and that was something that wasn't there. The court even distinguished between an action saying we're trying to compel enforcement of agreement versus trying to obtain damages. And what the court said was, in Kozel, that can't happen. Interestingly enough, Your Honors, in the Kozel case, they cite the 5th District's case that was ultimately reversed by the Supreme Court, but in the Palucci case. But what they talked about in there is that it was not proper for a trial court to have continuing jurisdiction over something that wasn't for a claim to enforce an agreement. And they sought the court in the Palucci case and the court in Kozel and other courts have said there is a difference between suing for breach of contract and general damages and enforcement of the agreement. And
well, Mr. Simarcos, and I'm sorry to cut you off there, but just looking at Kozel, I mean, Kozel, we're looking at the agreement. Would you agree with that? We're looking at the parties, the MSA, for lack of a better term, because in Kozel, their settlement agreement allowed for money damages. Here, there was a very specific allocation about how this was going to take place in the parties' agreement. Would you agree with that?
Well, the parties' agreement allowed in Kozel, what I thought the issue was that the party with the former husband was supposed to transfer stock and give her information. That was an obligation that he had that he, A, didn't perform timely, and B, when he did it, he gave improper information. And what the court in Kozel ultimately held was that's a breach of the agreement. It's not an enforcement action because you're not enforcing giving the taxes at a certain time and doing it. In our case, it's a breach of the agreement because the claim is that there was not a sale of the assets and a division of the property at the time the business was sold and what it was at the time the business was closed. The claim in this case is that assets were transferred post-divorce, that somehow claim, and it's even in the amended motion, a breach of fiduciary duty by the wife to the other corporation. So I would say that it's not for enforcement of the agreement, it's for breach, saying, because what the remedy sought is to say that the old daycare became the new daycare, transferring the husband's marital interest from the original daycare to an equitable interest in the new daycare. That's not enforcement of the agreement, Your Honor. That's a claim to say there's some sort of equitable claim for equitable relief that is being requested by the family law court to rule on and define. And also saying requiring the distribution of the sales proceeds as set forth in the marital settlement agreement. Your Honors, they're not trying to enforce the sale proceeds from the old company being sold because it was never sold. They're asking for equitable relief, saying, fine, the old company turned into the new company, and that there's an equitable interest in there that should be divided. And then there's a division of assets when the sale of all the assets of the new company take place, then the proceeds have to be distributed out to the former husband. So I would say that that's not an action to enforce the agreement. It's an action for breach of the agreement, trying to find certain remedies. One of them, equitable relief, saying this exists in the form of an equitable interest in the new company. And Your Honors, one critical distinction that we pointed out in the brief, these are over assets that were acquired after the dissolution, the real estate being a large component. The real estate sold for, at least under what was presented, $800,000 of the $900,000 sale. There was no real estate in the old co, and the former husband's trying to say, the court has jurisdiction over an asset that didn't exist at the time. And when that asset is sold in the form of an asset of stock in a new company, which I had no ownership interest in legally in terms of a piece of paper, then I'm entitled to half of that.
And Mr. Simarcos, I understand that your argument is that the old company and the new company are different companies. But at this point, we're looking at a motion for temporary attorney's fees. So that ultimate determination has not been made. Is that correct?
No, Your Honor, I don't believe it's been made because in the findings of fact by the trial court for the purposes of the motion, he found that it was the alter ego. The court specifically said he was finding that there was an intent to transfer to hinder the husband and that the new company became an alter ego of the old company. So by that finding, that is not just saying we're trying to figure out what's happening. The court made a determination and then said, now I have jurisdiction, because the jurisdiction issue has to be reached prior to being able to award the attorney's fees. And the court said, I find that the former wife did this as to defraud the husband and created an alter ego. And Your Honors, even my argument even is that even if there's an alter ego, that does not create jurisdiction over the entity. If the one case that's cited is the DeCampos versus Ferrara case. And in that case, and we've pointed this out, but why I believe that case is readily and easily distinguishable. The former wife had an obligation, and there was an obligation similar to this, that they were going to sell, the parties were going to sell the business called Plant Care, and they were each going to receive one half. The former wife claimed, I sold the business and I paid my husband $48,000 for that sale. And what the appellate court said was factually what happened was all of the assets of Plant Care were transferred to Plant Care Inc. She claimed all the liabilities and all the assets, and she sold it for $48,000. The former husband filed an action, said the $48,000 wasn't sale of assets. That was money due me under the agreement, under our marital settlement agreement, for construction costs for the house. And the appellate court said the trial court ruled in favor of the former husband, concluding the $48,000 was for the contributions to the construction of the home, and it did not represent payment for any interest or value of Plant Care. And so the court said now the former husband, because the business was not sold, is entitled to half of Plant Care. And that's it. The court didn't say, I find that there's an alter ego. I find that there's an equitable interest. The court said former wife did not sell the business for the $48,000. That payment was not for sale of the business, that payment only was for what the former husband was owed for construction. Therefore, Your Honor, that's why that case is distinguished. We don't have that. We have a business, Your Honor, that did not have a transfer of the assets and the new company starts the day after the old company. That's completely different. And the equitable claims that are claimed in here are even more remote because there's a new corporation formed with a new asset, specifically the real estate. And the assets are then sold later in the form of the sale that takes place years later when the real estate and the business are sold. And that's essentially completely different from the case of Palucci. I'm sorry, Your Honor, does that answer the question or is there something else you have in follow up to that I didn't answer? Thank you. Okay. The other arguments, Your Honor, that we've raised is that the former husband in this case is not entitled to recover attorney's fees to try and stop the sale of the real estate. The real estate was a separate action. The original arguments that were made on the motion had nothing to do with the new corporation. They were essentially equitable in nature, trying to stop it, have the husband involved in any of the sale. And as we pointed out, that hearing did not conclude. Rather, it was resolved, and it was resolved by a court order that said that the resolution was without prejudice to the parties. Essentially, Your Honors, the hearing didn't conclude. The parties agreed to put $200,000 from the sale proceeds into my trust account and that the list pendants was lifted. And there was not going to be any, you get to have this say in with a real estate broker or what we're going to do. It's just put $200,000 in and we'll argue this later on. Procedurally, what then happens is after the entity sells all of its assets, new company sells all of its assets, the money's put in my trust account, former husband then amends the motion. And now in the amended motion seeks new relief that was never sought in the first motion. And that relief is essentially, I want the court to declare my client, the former husband, has an interest in the new company and to have that interest declared to be owed for half of the sale proceeds that occurred from the assets of the new company. A completely different motion, which also we've argued and set forth, basically replaces the original motion because now it's moot and it doesn't exist anymore. It was resolved by agreement of the parties. So that there is no reason, Your Honors, to be able to have, there is no reason to be able to claim that somehow this is an enforcement action instead of what it really is. And that is an action to try and sue for breach of contract for a variety of claims that were raised. And we also argue, Your Honor, and I anticipate from Ms. Guthrie's brief, the argument is, well, we don't have all the transcripts from the hearing. Your Honor, they didn't put in any evidence at the fee hearing to say that the court has jurisdiction and that this is an enforcement action and that there were these transfers. There was no testimony from a teacher. There was no testimony from a parent. There was no testimony from anybody to say these assets were transferred over. The argument is, well, the court heard this in the first hearing, which there is no transcript of that's been filed in this brief, and therefore could utilize those findings of fact. They didn't even introduce the transcript into this hearing to say, here's the factual basis for which the court could rule on and say, this is why I'm ruling this and this is why I'm finding this. So that lack of supportive evidence is not on the issue. We've had this argument in our briefs, not on our burden to be able to say, well, where do you show that it's not an alter ego and where it's not formed? And as a matter of law, Your Honors, we've cited the cases that say the asset that's acquired, the real estate, cannot be subject to jurisdiction of the family law court because it didn't exist at the time of the dissolution action or the marital settlement agreement or the final judgment. Therefore, there cannot be an action filed later to say, I have a half interest through some equitable claims. And it's also critical, Your Honors, that the former husband is not saying, I'm suing for a specific dollar amount. That, again, is an enforcement action, but it's finding some equitable claim that exists because of a transfer of assets that occurred 2.5 years approximately after a new corporation is formed. And that's not allowed under the case law, and it's not allowed under the existing factual allegations that we pled. Your Honors, I see that I'm about a minute up. The only other issue that I wanted to address was a point that was raised concerning the lower court finding factually that something existed without any support. There is nothing in this record that the court could look at and say this transfer was done with the intent to defraud. And there's nothing to say that that new business in any, even if there was any commingling of any assets, that somehow this court being the FAMLA court, lower court, has jurisdiction to rule on the claims. So for those reasons, Your Honor, and the reasons set forth in our brief and our answer brief, reply brief, we're asked that the lower court be reversed. Thank you.
Thank you. Ms. Guthrie. You're on mute.
My biggest fear, sorry. May it please the court. Good morning, Your Honors. My name is Rebecca Guthrie. I represent Stephen Lewis, the former husband and appellee in this matter. Mr. Lewis asked that this court affirm the trial court's order on temporary attorney's fees and costs that was found in his favor for several reasons. First, we are here on a temporary attorney fee order, a temporary attorney fee ruling. As this court's well aware, temporary attorney's fees are within the broad discretion of the trial court, and particularly on attorney's fees are within the broad discretion of the trial court, and temporary attorney's fees are where the lower court probably has its broadest discretion. Appellate courts pursuant to the case law are, quote, loath to interfere with temporary attorney fee cases. Mr. Simarcos, through his arguments on the lower court and through his initial brief, have tried to couch the former husband's requested relief as damages. The former husband's requested relief in his pleadings, in his motion to enforce, which is a motion for contempt and enforcement, requests that the former wife be held in contempt for non-compliance with the party's final judgment and marital settlement agreement. And it requires that the court enforce the provisions of the marital settlement agreement, which have a very detailed plan for how to determine how to divide the proceeds from the sale of the asset that was acquired during the marriage. Mr. Simarcos has indicated that the plant care case, the DeCampos case, is far different and distinguishable from this case. I find that the DeCampos case is eerily similar to the case at hand. In the DeCampos case, we have the former wife had complete and exclusive control of a company named Plant Care. She was supposed to sell, upon the sale of that company, she was supposed to divide the proceeds 50-50 with the former husband. She sold that company, opened a new company called Plant Care Inc., exactly what Miss Lewis has done in this matter. She had it's easy to call the corporations, the old company and the new company. However, it shouldn't go without notice that the original name, the legal name of the first entity was New Beginnings Childcare and Occupational Therapy, then doing business as New Beginnings Childcare and Learning Center. As she closed that business through her own decisions and without informing or notifying the former husband, she started her own business, a new business called with the same exact name as the DBA of the old business. There was no indication to the former husband that there was a change in the legal entity or the structures or anything else. The former husband continued to be employed. He continued to be paid, and he continued to have a credit card by New Beginnings. As the name was a DBA in the new company, as the new corporation's name was the same as the DBA in the old company. So when that company closes, when the new company gets sold by stipulation of the parties, or when Mr. Lewis finds out that the company is for sale, he files the emergency motion to stop the sale, for an injunctive relief, to stop the sale of the business so that he can be involved in the sale pursuant to the terms of the marital settlement agreement. At that time, he had no knowledge that there was a new corporation, and only upon hearings, which we had several hearings during COVID shutdowns, handling the emergency motion, and the parties came to a stipulated agreement to sell the company, that he would agree to sell the company, he'd agree to release the Liz pendants, and he would, Mr. Simarcos would hold $200,000 in his trust account to account for proceeds that may be owed to the former husband, without prejudice to either party in any way. Of course, it only makes sense to modify the the requested relief through an amended motion for enforcement once the details of the situation came to light through some partial discovery in this matter. We also filed a motion for attorney's fees, and that's where the order comes from that the former wife is requesting reversal of. The attorney's fees hearing that was held in September of last year and January of this year, there was trial testimony. There was testimony from an expert named Mr. Bauman, who was approved as an expert, had done some preliminary investigation about the financials between the old company and the new company and the time period between when the new company was closed when the old company was closing and the new company was beginning, showing an inverse relationship in the financials. Mr. Bauman in the record indicates, I believe it's approximately page 22 of the record, Mr. Bauman indicates that there was in fact an inverse relationship, which would indicate that there was a transfer of one asset and to the other asset, including the intangible assets of the old property of the old company to the new company. Those intangibles include specifically goodwill. Mr. Bauman did not say the words goodwill, but he described goodwill and the transfer of students, and the good reputation of that company transferring from one to the other. That testimony is in the record, and it's in the record on appeal. The lower court judge used that testimony to come up to, as well as other testimony, of course, from the fee expert and from Mr. Lewis and Miss Lewis, to make a finding and to make specific findings of facts in the order on temporary attorney's fees. The temporary attorney's fees order, the former wife set forth a requirement through motions and through her memorandums and through her objections and Mr. Samarcos's arguments that the jurisdiction of this court was a threshold issue that must be answered prior to determining an entitlement to attorney's fees. The court entertained that and made a temporary ruling on that threshold issue. Of course, this is an interim and interlocutory order of the trial court. Therefore, it can always be amended at final hearing. If additional evidence comes to light that Mr. Lewis does not have a claim for any interest in the sale of the marital asset that was previously the old company and now it's the new company, then that will be determined at that time. But right now we're in the middle of litigation and of discovery where Mr. Lewis is entitled to an award of attorney's fees based on his need, based on Ms. Lewis's stipulated ability to pay those fees, and based on the other factors as set forth in Chapter 61(1)(6), including the litigation between the parties, the merits of the case, which the court clearly made an order, a ruling determining that his position, Mr. Lewis's position, was meritorious. Mr. Samarcos filed a declaratory, the former wife filed a declaratory action in civil court that was consolidated in with the family court. That is in the record indicating that the family law judge should hear this action. Mr. Samarcos made an argument in his initial brief indicating that the court keeps the two cases keep their individual status, but they're just being tried together. And that there's no objection to that happening. There's no argument from the former husband that they don't keep an individual, they don't keep their own entity, their own identity as separate actions. It just so happens that pursuant to the court's orders, the lower court's orders, the declaratory action is really an affirmative defense for Mr. Lewis moving forward on his motion to enforce.
And Ms. Guthrie, what impact, if any, do you think that our case, Flanders versus Flanders, has in this particular case, with now that this has been consolidated and as it stands currently?
So the Flanders case, the Flanders, just check my notes on Flanders, sorry. The Flanders case indicated that that case was reversed. The trial court case was reversed because The case was an equitable declaratory proceeding to construe that property agreement. And the former wife was awarded $24,000 in that distribution of equitable distribution in her monetary award. The appellate court stated that that pursuant to chapter 6116 should not apply because the former wife had sufficient funds to pay her own attorney's fees. So the court, the Flanders did not order that 6116 did not apply. It just ordered that she didn't have the need. Here, Mr. Lewis does have the need for attorney's fees. Miss Lewis has the clear ability to pay, and it was stipulated as such. So that is a clear distinction between that case and this case. It's not a prohibition of 6116 fees. It's just that case, that former wife had the $24,000. And I think that was back in 1989, approximately. So the $24,000 was sufficient to pay her own attorney's fees based on a need and ability to pay standard. When the court looks at the other cases that are cited by Mr. Samarkos, I think that they're clearly distinguishable, or the former husband has no objection to those cases, but they're just not on point and they're not relevant to this case. For instance, there's no argument that that the trial court should be rewriting the principles of the marital settlement agreement. That's not what's being requested. There's no question that the former husband is not entitled to quote damages. That's not being requested. So although it's been couched that the former husband is requesting damages, he's not requested damages, and he's not asked for damages. It's not set forth in any of his pleadings. The amended motion for contempt and enforcement does mention in the allegations that there was a fraudulent that Miss Lewis violated her fiduciary duties to the corporation, to the original corporation. But there's no request for damages based on that. If she in fact closed down a corporate entity, which was the old daycare, and transferred those assets that had value to a new daycare, then that is a breach of her fiduciary duty to that original corporation. But we've not requested damages for that. We've just we've set forth the foundation and the allegations upon which the court can find that there was a purposeful conveyance from the assets from one corporation to the assets of the second corporation in an attempt to really defraud the former husband of any interest in that marital asset. The fact is, the asset had value as of the time of the dissolution of marriage. It was valued in the wife's financial affidavit, and I believe that's in the record in the testimony, of approximately $70,000 back in 2009. The asset continued to function and it continued to perform well for a number of years until such time as the former wife purchased a different property. And she's alleged that that property, and this portion's in the record, it's in her transcript, it's in her testimony in the January 2022 hearing, that that the company, the space from which she moved, the old company that in the plaza, a new daycare is in that, the new daycare is in that building. So it's not that they couldn't continue to lease it. She didn't want to lease it because she bought a different real property and moved the company. The old company closed it down, started a new company without disclosing that to the former husband in any way. And that is still subject to a final, all of those facts and determinations are still subject to a final trial, at which time, if Mr. Lewis is without any grounds for relief, then the court can determine that. But at this point, and where we stand today is we have a temporary fee award where Mr. Lewis can investigate those claims, which we have a pretty good idea of what happened. But when Miss Lewis would like to pin down the husband on exactly what he's looking for, whether it was the value of the company as of the 2012, when it started to close, the old company started to close, when 2014, when the new company opened up and all of the assets were removed from the old company, or if it's current day value, that's going to be a determination of the trial court because the trial court has the authority to pick the valuation date that is appropriate in the situation as set forth in Chapter 61. For these reasons, the court does have continuing jurisdiction over this matter. The court has the standard that this court should review the record and review the order is for an abuse of discretion. The trial court has the discretion in determining the appropriate relief in a matter, whether it has jurisdiction to continue to give certain relief, whether it's been pled appropriately. We assert that our requested relief has been pled appropriately. The court has jurisdiction in this case. The trial court has jurisdiction to award attorney's fees. And the former wife should not be able to prohibit the former husband financially from seeking enforcement of the marital settlement agreement because of the great disparity in their economic circumstance. If that were the case, theoretically, any spouse could take a jointly owned marital business, shut it down post-filing, start a new business with a very similar name, just add an INC to the end, and then tell the former spouse, I'm sorry, you don't have any, you have to go away. I don't have to pay you anything. Everything's gone. Your interest has died with that original corporation, which I had complete access, authority, and control over. And that would be completely inequitable in this case. It would be completely inequitable in any case. And that's why the DeCampos court allowed the former husband to have an interest, a 50% equitable interest in the sale proceeds from the Plant Care Inc. company. I'd also want to point out the Cease v. Cease case of the Second District. Mr. Samarkos continues to argue that this court does not have jurisdiction of any asset that was acquired post-filing. In Cease, the parties, because of the settlement agreement, and again, we're basing our position on the language in the settlement agreement. Mr. Lewis is basing his position on the language in the settlement agreement. That in Cease, that settlement agreement said the parties would equally divide the former husband's retirement. At the time of the enforcement action, the former wife was awarded by the trial court the value of the husband's retirement as of the date of the petition, of the entry of the final judgment. On appeal, the appellate court reversed and said the plain language of the marital settlement agreement stated that the former wife, that the parties would share the entirety of the husband's retirement. So that retirement account was valued. In that case, I believe it was about 15 or 20 years later post-filing. So all of those proceeds and all of that growth and gains and additional contributions post-filing were awarded to the former wife based on the language of the parties' agreement. So in this case, we're requesting that first we're requesting that the attorney fee order be affirmed so that the former husband can continue to determine what his interest would be and what that valuation date would be, and so that we can get to the end of this case and he can find out what exactly he's entitled to. Coming from a place from not knowing anything, not knowing there was change in businesses, not knowing there was a closure of the original business or the startup of a new business, he was at a handicap. And the court's determination that attorney's fees were appropriate in this action, in the lower court action, should be affirmed for those reasons so that the court can get to the end result of what his interest should be at a final hearing. I know I have additional time. I don't know if the court has. I think I've covered all of the points that I was hoping to cover.
Okay, thank you, Ms. Guthrie.
Thank you. Thank you, Your Honors.
All right, Mr. Samarkos, you have just over 5 minutes. Go right ahead.
Thank you, Your Honor. I want to try and focus on some critical points because this is not an action to enforce the marital settlement agreement, and that is in the wherefore clause of the former husband's motion. He asked for a finding that through the actions of the former wife, the old daycare became the new daycare, and that there's a transfer of the former husband's marital interest from the original daycare to an equitable interest in the new daycare. That, Your Honors, is not an enforcement action. That's an action essentially for breach of an agreement with equitable remedies that are being attached to it, similar to either a constructive trust or some sort of resulting trust, I would guess. But that is not relief to enforce it. The next part after that says enforce the terms of the MSA requiring the distribution of the sales proceeds. We know there were no sales proceeds in the record from the sale of the first company, the initial business. It's only the new company that was formed 2 years later, operated simultaneously for a period of time for almost 2 years, and then the major asset real estate that was sold and acquired. There is a major difference in this case and the other cases because the former husband's not saying, I just want to have my interest in this business. It's not that, Your Honors. It's finding that new business is actually something he has an equitable interest in. That's why there is no jurisdiction in this case, because they're asking the family law court to do something it had no jurisdiction to do, not to enforce the agreement, because nowhere in the agreement does it say, if somebody does something wrong, the remedy is that you get an equitable interest in the new entity. And I think that's why the case that with the plant care, the former wife claimed, I sold that business. The court said, no, you paid him for what he was owed. You didn't sell the business. That's completely different here. They're arguing his equitable interest should transfer over if he had an equitable interest in it. There he had an interest arguably contractually through the agreement. But that's a major, major difference. And Your Honors, we're not arguing here that the husband has no judicial relief. The issue is under Chapter 61 and the award of attorney's fees, that the former wife is paying the attorney's fees, saying this is a Chapter 61 case. He has any legal remedy that's available to him. And it's also, we filed this, it's disingenuous to say he had no idea there was a new business. He worked at the new business, the new location. He entered into, and will be alleged in the DEC action, a settlement agreement, a general release where the former wife paid him money, and he released the entity that he was now claiming he has an equitable interest in. So there is record evidence that he knew there was something else going on, and he entered into a general release. If he thought it was the same company, then he released the entity. But his claims are essentially, I'm entitled to assets from the entity that was sold, and he wants it through the form of some sort of equitable relief that's being done. Additionally, Your Honors, the fact that there are two separate locations is critical. One had a lease, and the lease expired. It wasn't that she didn't want to keep leasing it. The testimony, I believe, would be that the lease was too much to be able to continue, and she didn't want to do that. And also, Your Honors, the marital settlement agreement only allowed for basically half of the sales proceeds. All of the profits during the operation of the business that were in the old company were to go to the former wife. She operated it. It wasn't that he had an equitable interest as an owner where he's entitled to profits. The only thing that the former husband was entitled to was if it was sold, and it didn't dictate who sold it or when it was sold. And the entity shut down. They're not saying in the family law court, we want to value what that business was worth at the time of closure, and whatever that value is, if it was transferred, we want half of that. They're claiming we want this family law court to find the old daycare became the new daycare, and that transferred the former husband's marital interest from the original daycare to an equitable interest. That is critical, Your Honors, to why this court, the family law court, does not have jurisdiction over this action. That is not an enforcement action. That is an action for declaratory relief, finding something happened, finding the remedy for what is alleged to have happened. And then the basis of that is now we're entitled to fees because it's a family law action. And with that, Your Honors, I'll save 51 seconds for the rest of the folks arguing today. And I appreciate, I'm sure as Ms. Guthrie does, your time and consideration. And we ask for reversal. Thank you.
All right. Thank you. Thank you both very much. Very well argued. And with that, we'll stand in recess.
Thank you.
Your Honor.